Well, I have straight up 6. We'll go ahead and officially open the meeting. Board of Zoning Appeals of City of Westminster is now in session. Called to order. First order of business is the approval of minutes, a summary from our last session on December 1st. Has everyone on the board read those minutes, and do I have a motion?
So moved.
A
To
second.
approve.
All in favor? Aye.
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 Unanimously approved. I will sign.
Andrew, a quick question. Why you have them as minute or meeting summary as opposed to minutes? Is there any reason for that?
That's just a practice. Vice Chair Barrett, that's just a practice we've been doing for last couple of years.
Oh, you mean I'm just finding that out after 2 years.
I don't.
No,
think
don't worry about it. I'm
Okay.
just curious. No problem.
Okay, with that approved, we'll move on to the first case of this year, case number 21-01. Oh, I should do introductions first. I'm sorry. So everybody knows who we are. Ahmed Kramer, Chair of the Board. Board members.
I'm Larry Brent, Vice Chair.
I'm Brenda Frazier, board member.
Eric Blitz, Board Counsel.
Mr. Gray.
Andrew Gray, Planner, City of Westminster.
Mr. Depot.
I'm Mark Depot, the Director of Community Planning and Development for the City of Westminster.
Thank you all. Cindy, Ms. Young, do you want to introduce yourself?
Yes, I am Cindy Young. I work for Kreger Construction.
Is there anybody else there with you want to introduce?
Yes, I'm Steve Gamber. I'm project manager for Kreger Construction.
Okay, thank you. Case number 21-01, an application by Cindy Young of Kreger Construction on behalf of property owners Paul A. and Megan E. McDonald, requesting approval of a variance to the required minimum least side yard setback of 8 feet in Article 7, R 7500 residential zone, 164-37C bulleted 1, dimension requirements for the city zoning ordinance in order to allow a new deck to be 3 feet from the property line to be located at 35 Westmoreland Street in Westminster, Maryland. Typically, we start out with comments from city staff. However, I would like to, at this point, raise the issue and ask Ms. Young if there's any particular reason why there was no pre-hearing statement as required by the code.
Well, I've never done this before, so I had emailed in. I believe I wasn't able to reach anybody to ask if that's the standard operating procedure. So that's bad on me, yes, but this is all new and I just didn't get it completed.
Typically, we have options based on that to either proceed, and that would be a function of discussion of the board as to whether to continue. So I'd like to ask the board if they have an opinion on this at this time.
I would be fine with moving forward after hearing the testimony.
Yes, I would be fine with that as well. I think there are some issues here, but I think we can address them without the pre-hearing statement. If we get bogged down, we can always continue the hearing and come back another day.
Okay, I guess I'm generally in agreement. Even though this is a variance, we've had cases like this before. They can be pretty straight away, or they can be a little more complicated. So with that in mind, I'd also ask staff, do you have a view one way or the other on going forward, proceeding?
If that is what the board wishes, unless Mark, Mr. Depot, you have any objection?
My only concern is that if there's information that's required by the rules of procedures by the Board of Zoning Appeals, and that information is not provided, and the Board of Zoning Appeals continues and makes a ruling on a case that doesn't have needed information that should be before the board, I would just be concerned that if this case is appealed, whether the board made the correct decision to move forward with the hearing. But again, and maybe Mr. Blitz can chime in, but ultimately it's, I just want to ensure that the Board of Zoning Appeals is covered and moving forward.
So, Ed, do you want me to chime in?
Yes, please, Mr. Blitz. I was going to come to you next.
Okay. So the obligation of an applicant, and for that matter, those seeking to oppose an application to file a pre-hearing report is mandatory under Section 8. However, a rule of procedure that isn't required by the board, by statute or the ordinance, can be waived if there is a provision that suggests that it can in the process, as long as no party is prejudiced. And that would include city staff, because in their staff report, they noted the absence of a pre-hearing report. And so if they felt any bias or prejudice, I should say, not bias, prejudice for not having the pre-hearing information report and therefore not being able to do as complete a review in their staff report as they would ordinarily want to or like to or could have, then, and you've gone to them. Under subsection 4, it deals, this is subsection 4 of section 8 under the pre-hearing requirements of the board. Failure to comply with sections 8, 1 or 2, and 1 is the pre-hearing report, it says may be cause for refusal to accept the pre-hearing statement and or cause for postponement, continuation of the hearing and or decisions to leave the record open for a specified time to permit rebuttal evidence. So in that context, that's your hook upon which you can waive the rule, because it says may be cause. Even though the obligation of the applicant is mandatory, it gives the power of the board to make the determination as to whether the failure to file the report should result in any of those things. But I would stress to the board members that if staff feels any form of prejudice, including as you proceeded through the hearing and they said, well, wait a minute, we would have been able to address this by a site survey or any number of ways that they could have been prejudiced, then they should alert you now, or if they feel that prejudice, or later during the hearing. And then you would then, if you were to proceed and not postpone, continue the hearing, you would then either decide then and there to continue the hearing so that you could address those things. And I think you touched on that. So Mr. Depot is correct that it is a mandatory requirement. I don't think it would be an appealable issue, just because you do have under subsection 4 the power to deal with the consequences of the failure to file a report. And I should say also that the board is also empowered to actually dismiss the case for failure to file a report. So you could go the opposite direction and be more draconian.
Yeah, if I could speak, I spent much of my career in the corporate world in front of boards just like this, in many, many states. And I got a little frustrated with some of our attorneys, and I'm an attorney myself. If I'm spilling too many beans here, I apologize, but I'm quite happy that I don't want to, have everything postponed at this point simply because of a certain provision hasn't been followed. We always, as the board, always have the right to continue the hearing, and I'm sure if Andrew or Mark were concerned at the way the hearing was going, I can't speak for the board, but I would certainly vote to continue it or ask additional written information, from the applicant. So I'm comfortable the way, taking it forward. And if we get bogged down, then we'll come back. That's my opinion.
Given that, and given what Mr. Blitz said, let me come back to Mr. Depot. I guess you first, being a senior, and then see if you have any reflection on what Mr. Depot said about any prejudice.
It's a difficult to respond to that without an actual statement or pre-hearing statement. It makes it difficult as to whether there would be some prejudice or issue with staff. We may have provided additional information or provided some additional options for the applicant had we been given that statement. Additionally, I believe we probably would not have been in front of the Board of Zoning Appeals tonight absent the pre-hearing statement. It was an advertising issue that we've already paid money for advertising in an effort to save the applicant money and not have to re-advertise the case. We felt that moving forward and recommending continuance for next month would be appropriate, because otherwise I would not have placed them on the Board of Zoning Appeals hearing tonight. I would have held off till the following month and re-advertised for this case.
Okay. Let me ask Ms. Young, based on your introductory statement and I'm sorry, response to my question about the pre-hearing statement. Have you received a copy of the staff summary? That outlines the city's position?
I think
Your audio is off.
it's not showing as off.
Oh, it's not. You're right.
I can hear you. Can you not hear me?
Yeah,
Now we
here
can, yes.
I don't know, Mark or Andrew, did you send me that? If you did, then I have it. I don't know.
Yes,
Okay.
yeah, Ms. Young, that information was sent on Friday, or sorry, Thursday, this past Thursday, New Year's
Okay,
Eve.
then yes, I have it. And I know you sent me a copy of a pre-hearing statement that was done for another case to compare to. I don't have a lawyer or anything of that nature to give that type of a statement. That's why I didn't provide that. I don't have that information.
It sounds like she's clear as to, sorry to interrupt, Ms. Young. The question is whether you received the staff report.
Yeah, I must have, because Andrew said he sent it to me. So yes.
Because that's different than
The
the
staff
pre-hearing.
report is what the city would attest to here, and what all board members have, that outlines their review of the case. And in part of that talks about the fact that on November 23rd, Mr. Gray provided you, the applicant, with the requirements of the Board of Zoning Appeals based on the city's ordinance and the rules and our rules of order and procedure. And then also did a follow-up on December 10th by email requesting the pre-hearing statement. Did you get both of those communications?
Yes, I did.
And did you respond to them?
I did not do a pre-hearing statement, so I did email back to Andrew, and I believe he was out. And then Mark responded. I don't believe I got to Andrew until the day of or the day before that pre-hearing statement was due, asking, is that standard operating procedures? Because I wasn't sure. And
I would think, and I'm sorry to interrupt. I think Andrew did a really good job with the staff report, and the board wants to continue to hear the case. Again, I don't have an issue with that. I was more worried about what the cause and effect would be, and I think Mr. Blitz explained that. I think if you look at the staff report, Andrew highlighted each of those points that we're looking for some comment from the applicant. So maybe as we move forward with the process, if you do want to hear it tonight, Ms. Young can maybe address those issues.
Well, inasmuch as she hasn't said that she has gotten the staff report, then I would hope that you've looked at that and have prepared a response to those things that the staff report says were not addressed by virtue of not providing the pre-hearing statement. It's really not a complicated process. It doesn't really require a lawyer. Of course, legal counsel is always allowed, the applicant's always allowed to seek legal counsel and have them go through that process for you. But just so that you'll know for future reference, it's not a highly complicated process to be able to look at the city's ordinance and respond in kind to the specific questions. But having said that, and with the board's discussion, Mr. Barrett's recommendation, I think I think we proceed so as not to hold it up and not to cause you, the applicant, additional cost or the city additional cost in time and money. That seems the best way to proceed. But I just wanted to bring that up in the beginning because it could become an issue. If there were anybody who was also going to be attendant to this hearing in a formal sense or just in a observation out there observing how we're conducting business, it's important that we make these matters clear. So having said that, I will ask Mr. Gray to provide whatever summary he wants of the summary, the staff summary, and that's how we normally proceed, and then we'll move on from there.
Mr. Chair, if I may,
Yes.
can you give me 3 minutes? I would like to coordinate with Mr. Depot with the screen share with proceeding with the case, if that is all right with you.
Fine with me. The board have any objection?
No.
Go ahead.
Thank you, Mr. Chair. Mr. Depot, I will give you a phone call.
Okay.
So, Mr. Chairman, are we still on the record at this point?
I believe we are. That's the first time we've ever had this situation, but
I just,
You're on
I
the
guess
record, but let me intervene, Larry, to make sure you're not commenting on this case outside the absence of the staff being able to witness it. That is on the record.
well, I will ask, I'm going to ask the applicant a question. If you think it's out of order, I'll withdraw it. My question is to Ms. Young. If this hearing were postponed or delayed or continued, would that create problems in terms of your schedules?
Yeah, so you should not answer that, and that question should be asked immediately after Mr. Depot and.
Okay, that's fine.
Sorry to be the line that one.
All right. I will just pause until Mr. Depot gets the PowerPoint up.
Is it?
Okay, and then Mr. Depot, are you that back?
Yes.
Okay, so Andrew Gray and Mr. Depot are back. Mr. Barent asked a question that I asked him to ask again when you were present. So
Yeah, my question was to the applicant, just procedurally here. If for some reason this case were to be continued, say to the February meeting, does that cause you any issues in terms of your plans, time-wise?
Oh, while the weather holds, would certainly be better than getting into February when we could have ice and snow, and the homeowner's eager to get it going. So, you know, we would like
Okay, I'm
to.
just curious. Okay, thank you.
All right.
Okay, Mr. Gray.
Thank you, Mr. Chair. Mr. Depot next. The location of the property is located in the R7500 zone, located 53 feet southeast of the Maryland Avenue and Westmoreland Street intersection. Next. For the first standard for a variance, the information provided by the applicant did not address the standard. Testimony by the applicant should include any exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes of uses in the same zone. The applicant wishes to place a 12-foot wide deck on the rear of the single-family detached dwelling unit located on the property. According to the Maryland Department of Assessments and Taxation, the property was built in 1923, which predates the zoning ordinance, thus making this an existing non-conforming use. The property has a least side yard minimum requirement, according to the zoning ordinance, of 8 feet and a sum of side yard minimum requirement of 16 feet. The dwelling would be considered, as I mentioned before, an existing non-conforming use. According to the information submitted by the applicant with Carroll County Building Permit Application RD 20-2560, the property is 40 feet wide. This width would leave enough room for the deck to be constructed a minimum of at least 8 feet from both side property lines. According to Maryland law, the applicant has, according to Maryland law, the modifications in a variance may be only allowed where, owing to conditions peculiar to the property and not because of an action taken by the applicant, a literal enforcement of the zoning law would result in unnecessary hardship or practical difficulty as specified in the zoning law. The applicant has not demonstrated any unnecessary hardship or practical difficulty to justify the need for a variance. nothing would prevent the deck from extending from the existing porch on the southern corner of the home and extending around the rear of the house until the deck is approximately 8 feet from the property line. The applicant has created the need for such variance as a result of action taken by the applicant or predecessor in interest of the property. Number two, the information provided by the applicant did not address the standard and of any effects on the preservation and enjoyment of substantial property rights possessed by other properties in the same zone and in the same vicinity. Nothing would prevent the deck from extending from the existing porch on the southern corner of the property and extending around the house until the deck is approximately 8 feet from the property line. And the third standard, the information provided by the applicant did not address. Testimony should include how authorizing such variance will not be of substantial detriment to adjacent properties and will not materially impair the purpose of this chapter or the public interest. If this variance was approved by the board, such variance would materially impair the purpose of the zoning ordinance, as all similar properties in the R7500 residential zone are subject to the 8-foot minimum setback requirement. In conclusion, staff, we have, and I know this is up to the board, but we have, we recommend that the Board of Zoning Appeals vote to continue the hearing for Board of Zoning Appeals case number 2001 to Tuesday, February 2nd, 2021 at 6 p.m. in order for the applicant to provide a pre-hearing statement pursuant to the Board of Zoning Appeals Rules of Order and Procedure. And Mark, I apologize. I apologize to everyone. I forgot to say next, but I guess we would be then on the last slide. Thank you, Mark, and thank you. And Mr. Chair, if I may, I would like to enter the applicant's application into the record as exhibit number 1. And I would like to enter the staff report into the record as exhibit 2. Thank you. If anybody has any questions, let me know. And the applicant is also here as well. Thank you, Mr. Chair.
Introduction and acceptance of the exhibits. It's accepted by the board. Mr. Blitz will so note. Does the board have any questions of Mr. Gray?
I don't.
I don't at this time.
I have two questions. Oh, sorry.
I have a question. Oh, I'm sorry.
No, you should go first. I was thinking that the board had done.
The picture that I guess is drawn from the SDAT or whatever that shows the property location with the star in the midst of that whole development.
Yes, Mr.
It looks
Chair.
like it just looks like all of those homes are pretty much built the same way, may have pretty similar, if not the same, setbacks, if you will, given when the property was built. They're all pretty tight. And in that regard, on the smaller drawing, showing the setback on the left side of the property line over there, closest to where they're proposing to do that deck. Is that 3.5 feet or 5.5 feet?
Mr. Chair, I believe that's 3 foot plus or minus. I don't know if
Oh,
Ms.
okay.
Young, is that correct?
She hasn't been sworn yet.
Oh, all right.
All right. It looks like 3 feet something. I just was wondering what that dimension really was. And then to your statement, I'm a little fuzzy, might be just me. The last sentence, that talks to that goes to, let me see, I'll probably be best to point it out by page. On page 6, top of the page, the last sentence, the applicant has created the need for such a variance as a result of action taken by the applicant or predecessor in interest of the property.
Yes. Mr. Chair, may I?
Yeah, please.
And the reason that is in the staff report is because the sliding glass door, which does not look like it was original to the home. So the sliding glass door should not dictate where a structure would be outside the home.
All right, that's what I was looking for. Thank you.
You're welcome.
Okay, at this point, I need to swear you, Miss Young, and if your associate there is going to give any testimony, I need you both to swear. So if you would raise your right hand, please. Do you swear or affirm under penalties of perjury that the testimony you are about to give is the truth?
Yes. I thought you were no separate.
Did I hear a yes from both or one?
Yes.
Yes.
Okay, thank you.
Mr. Chair,
Yes,
I have 2 questions of staff, both trying to just clarify things for the record.
all right, go ahead, please.
First, you have what appears to be a representative acting as the applicant and the homeowner as just signing off. And my concern is whether they have an interest, a legal interest in the case. That is, under the rules, the applicant is supposed to have an interest. So if they're leasing from a property owner, they have a leasehold interest and they have an interest in bringing the thing. But why is the contractor, unless we're about ready to hear, I'm concerned that the contractor isn't the proper party to be an applicant. And I just wanted to know what your thinking on that was.
Are you asking us, or I'm sorry?
Ms. Young?
No, I was addressing that to staff actually, because they
Oh, I'm
made
sorry.
I'm sorry, is Eric, are you saying that, and I apologize, I don't have the application in front of me. The application itself is signed off by the contractor, not by the property owner?
Well, they are both signed it, but the applicant is listed as the contractor and then your property owner. But a contractor isn't an applicant. They don't have a legal, unless they do have a legal interest, and we're about ready to hear. So that's why I was directing it to staff to see whether this had been vetted before. But like this would be almost like having the attorney representing a party be listed as the applicant. You know,
I understand completely. My understanding is that Ms. Young is representing the applicant as the builder for the applicant, but the applicant would be the property owner if it wasn't properly done in the application. That is my understanding. The applicant is a property owner, and Ms. Young is representing the applicant as the builder for the deck. But I may be incorrect, and if Ms. Young could address that.
No, as a general rule, when we do permits for our customers, I take care of that for them. So when this came up for needing the variance, I told the McDonald's, I said, either you can file it or I can take care of it for you. So they said, if you don't mind, go ahead and do it. So that's the only reason, just as a service to the customers, to not have them have to do it. We don't have any financial interest in their property. It's just trying to help them out.
so the issue then presented is, for the purposes of notice under this case, was the applicant listed as the McDonald's, or I'm asking that question to inform the board, because ultimately they would decide whether sufficient notice has been given that would allow the record to be cleared up that the applicants under this case are Paul A. and Megan E. McDonald, and that Ms. Young and Krager Construction are merely representatives of the applicant.
Well, if I may say, when I sent in the application, it clearly, I filled in my name and Krager Construction as the applicant. And then the property owner information was below that.
Correct.
So,
That's the problem, is that you're not a valid applicant.
okay, well, I was not told that, so I don't know what to say to that.
Mr. Chair, if I may.
Mr. Gray,
The notice has an application by Cindy Young of Krager Construction on behalf of property owners Paul A. and Megan E. McDonald.
Okay, so the board could conclude that that is sufficient to give notice that the property interest holder, the one that has a legal interest, has been included in the notice to everybody else that would be heard, including them. I believe they get a copy as well. And so I just wanted to make it clear who the applicant was, and then the board should rule now on whether the notice is sufficient.
do I have comments from the board?
The notice to, I'm sorry, Eric, the notice to who?
To the public. That is,
the
we
public.
publish the notice, that same
Okay.
notice that Mr. Gray read gets published twice in the New Carroll County Times, gets put on a certified letter to all of the adjacent property owners, and it gets posted on the property, and that gives the legal basis for giving those property interests that may be affected by this decision to appear. So the question on any notice case is whether, or notice issue, is whether the notice is sufficient to give an ordinary citizen notice of what the case would be about and who is applying. And I think as constructed, it lists both Ms. Young and the McDonald's in that notice. I just want to have the board rule that that notice was sufficient, and that the actual applicant in this case, for the purpose of the decision, will be Paul A. and Megan E. McDonald.
And Andrew, it was listed as both names when any disclosure was made to the public.
That is correct. Yes, all of them had an application by Cindy Young of Krager Construction on behalf of property owners Paul A. and Megan E. McDonald.
Thank you.
You're welcome.
With that information, because it's on behalf of, I'm
So
comfortable.
they're all consistently stated that way.
Okay,
I'm comfortable as well that the notice provision has been, has been completed,
Mr. Chair,
sufficient.
and Mr. Chair, if I may.
I'm having trouble hearing. I didn't hear Larry very well. I'm sorry.
I'm just saying, I agree that the notice, applicants notice that they were acting on behalf of the property owner, that it's sufficient notice to the public, in my opinion.
Okay. Mr. Gray?
I'm just going through the notices, and it does, every one that I see has an application by Cindy Young of Krager Construction on behalf of the property owners Paul A. and Megan E. McDonald.
Okay. All right. Given that, it seems like, it seems like that was fair notice, and and as much as no one asked to be heard one way or the other, I think it'd be appropriate to proceed. Mr. Blitz, do you have any further comment on that?
just one other question. When Mr. Gray read his report in, he read the request that the case be continued, yet we had previously dealt with the fact that I think staff was taking the position they were okay with it proceeding, but I didn't know whether they, by reading that into the record, you were intending to renew that motion or to change your mind. I just want the record to be clear, because you're the only party that's present that would have the right to claim prejudice.
And Mr. Blitz and Mr. Chair, if I may.
Yes, please.
My intent when I read that to reread and carry that same recommendation forward. However, if I may I consult with the zoning administrator just for his quick opinion via phone, and have a quick 2-minute recess while I do that?
Well, would it be more appropriate for Mr. Depot to comment on the record here?
And I could do that. I think ultimately being that, again, without the information that we would find necessary to make a determination or a different recommendation, we would still recommend that it's continued for the next month. That's not to say we can't hear the case and it could be held open until the following month, but I think we still hold to that, absent, again, applicants' presentation and information they might provide might sway our recommendation, but I think we still want to hold the same recommendation.
Could I make just one comment since? is
Sure,
that
go
possible?
ahead, Ms. Young.
Okay, since you already have the plat up, just so you're aware, the stairs that are showing on their existing are the width that they are. We are not going any closer to that property line than what's already there. We're just extending towards the back, which there's plenty of property there. So it's only that side yard. But as I said, we're not going any further over than what the existing structure of those stairs coming out of their back door.
Understand.
Okay.
I mean, that's pretty evident by the drawing. Does the board want to make any further comment in response to Mr. Depot's last comment there?
I don't
Proceed.
know.
So do we proceed? And if we get to a point where things get, not clear, then we go for continuance from there. Is that what I'm hearing?
Yes, for me.
Yes.
Okay, then let's proceed. So having sworn you, Ms. Young, and I couldn't see a hand of your associate, I'm sorry. I couldn't even see your hand for some reason, but I presume you did. So it's now on you to address those issues and talk us through meeting the requirements that are required by the code. And we will ask questions as you testify.
Okay, so first of all, Mr. Gamber had to leave because he had another appointment. So I'm sorry. He's the project manager and he had to go.
All right.
So it's just me at this point.
Okay, thank you.
So what exactly am I supposed to tell you
Well,
other than,
If you have a copy of the staff report that starts on page, well, actually it starts before that, but the issues at hand start on page 5.
I
If
did
you
not,
have that,
I did not print that out, so I don't have that in front of me, and I'm worried if I leave this page, I will lose you all, so I'm not able to pull that up.
it sounds to me then like you're not really prepared to do this. So I think our only choice is to move for continuance.
Yeah,
Now,
agree.
realizing, of course, that Ms. Young, you as the applicant now will bear the cost of additional notifications.
If you're doing a continuance, you shouldn't need one as long as you set it for a date certain.
So given the original recommendation from staff and what is typically normal is we would continue to the next available board meeting date, which would in fact be on Tuesday, February 2nd at 6 p.m. So
And
I would
one-
make I would move that for continuance for Tuesday, February 2nd at 6 PM. Do I have a second?
Hold
Second.
on. Was it February 2nd?
February 2nd is what I think is the next date. That's what Mr. Gray has in his summary report,
Okay. And then
his
the,
staff report.
and if I could just ask a question, are you also asking Ms. Young to file in advance of that application, her pre-hearing information report?
Yes, that's another contingent here that Ms. Young, you should then work with city staff to the degree that you have to, but pull up that staff report and make sure that you would provide a pre-hearing statement to answer those requirements. That's part of my motion. So Larry, you want to second again? If you're gonna
I'll second it again. Yep.
All in favor?
Aye.
Aye. Unanimously approved. So we will meet again on the second, contingent on Ms. Young providing the required information. I'm not aware of any other business before the board. Mr. Gray, any notice of February requirements otherwise?
No, Mr. Chair, there are, and currently there are no other applications pending before you except for this case 21-01.
Okay, thank you very much. Any other business from anyone else? If not,
If
we are
I,
adjourned.
I'm sorry, Miss.
Whoop, I'm sorry, go ahead.
I'm
Go
sorry,
ahead, Mark.
Ms. Young, I'll have Andrew set up a meeting with you and we'll go over the staff report and other elements to try to help guide you as to what we're looking for that pre-hearing statement for next meeting.
Okay, thank you. I appreciate it.
All right, thank you everyone for your time and we'll see you next time. We are adjourned.
Good night.
All right.